Welcome to another of our oil and gas law podcasts. My name is Tom White, and I'm here with my partner,
Kate Kimball.
And we are here to try to make a little bit of common sense out of a very difficult area of law, the oil and gas law in the state of Ohio. We enjoy discussing this, and we hope that you enjoy listening and watching this podcast, because what we're about is trying to empower folks, especially landowners, because we're landowner advocates, in the understanding of this very complicated area of law. If you would like us to look at your lease, please call for a consultation at 330-231-1195. Lease, sale, pipelines, royalty issues, anything dealing with that, we'd love to talk to you. So this morning, my topic is going to be discussing with Kate about breaking a lease, about what held by production means, and then you'll hear a common theme through this that I call "it ain't necessarily so." Okay, some
Sure.
common sense concepts here that really don't translate well sometimes into this area of law. First, on one of our educational tours, I remember being in Marietta. This would have been like 2014 or so. And I remember coming out of the conference. It was at a hotel in Marietta. And I saw this old man and this young man, and they were really intensely arguing. And they, after I listened to it a little bit, they were really into it. The older man was talking about their farm's mineral rights, the right to produce oil and gas from underneath their farm. And he was arguing, we could get a good price for selling our mineral rights. We get the money up front, it's guaranteed, and quite honestly, we don't know what's going to happen in the future as far as production. The younger man was arguing, no, if we lease the property, we get a sign-up bonus, and if they drill under us, then we get money in royalties over a much longer period of time. And they were really upset with each other over this. And then all of a sudden, this lady walked up to me and said, "Are you concerned about those two?" And I said, "Yeah, are they going to fight?" And she says, "No, that's my husband and that's my son. They're arguing about our farm." And that kind of points out how you look at selling your mineral rights, which means to some producer or some other person, there are companies that buy mineral rights, and you get paid up front, but you're probably not going to get paid as much as if you lease with royalty coming in if they drill under you, if most of your acreage is included in what's called the production unit. Do you find sometimes, though, people get confused about the sale versus a lease of mineral rights?
I do. Pretty often I get calls where people have maybe gotten offers for both, and they're not always clear on what the difference is. So if they're not sure which one they want to pursue because they don't necessarily know what they're getting in the mail. Because like mineral buyers will send letters out and just say, we're offering up to some amount, or we're interested in purchasing minerals around your property or something like that. And I think sometimes people think about it as being a lease, but I've also heard people talk about a lease being, they'll say like, "Oh, I sold my minerals in 2012. And when we see the document, sometimes it's a lease, because they're thinking that they sold the right to do something, which is what a lease is, right?
Right.
So they're related, but they're different. And I think about it like long-term, what are you keeping or not? And that's the difference between a sale where you'd be conveying it away. You're selling, which maybe sometime we'll talk a lot about mineral sales, right? You might be selling just royalty interest or selling all mineral rights or anything in between, compared to a lease where you're giving somebody the right to produce there. And in return, you get paid a royalty and a bonus and things that your lease would say.
And supposedly, a lease is something that doesn't last forever.
Supposedly.
Right? But it ain't necessarily so, at least in the minds of the producers of those. So the first thing that you folks need to do who are listening to this is, if you're presented with a a potential offer from an oil and gas producer is, what are they asking for? Are they asking to purchase your mineral rights, or are they just asking to lease them? And the two things are very similar with regard to your rights, with regard to production, et cetera. But that's an important first fact we have to look at. So, and especially the concept that, well, you think a lease should be for a period of years, and then it's over. It's like if you rent an apartment, or if you rent something else. If you rent a storage unit, you're renting it for a certain period of time. As long as you pay your rent, it's yours to use, and then it ceases. But it ain't necessarily so when it comes to oil and gas leases.
Right. It isn't.
So this is an area of law where we talk about leases, which is what most people have. And some of them are based upon very old oil and gas leases, where the term is the so-called shallow wells versus the deep horizontal wells that we're dealing with now, were drilled over time and have produced some. The majority of the landowners who got into those leases were not, of course, not interested in large amounts of royalties, because these wells just didn't produce that much. What they were interested in was the concept of free gas.
Right.
And that is very important to some farmers, right?
Right. It is.
So, and this is an area that if somebody comes in and says, listen, I have this lease, it was signed by, let's say, my grandfather in the 1950s. We've seen leases older than that are supposedly still alive. Am I able to break or get out of my oil and gas lease? And leases, like deeds, have what lawyers call a habendum clause. And your definition, real quick, of a habendum clause is?
I mean, I would kind of summarize it as being, you said something a minute ago about a lease being alive. I would think about it being, the lease is alive for X years, or so long as Y happens.
Right.
And that could be, a lot of times in leases that age, we would see as long as there's production and paying quantities. Or I've seen leases that mention things like, if the property is capable of producing oil and gas, which that's very broad.
It is very broad. Yeah. So a lot of these leases will have, this lease is for a specific period of time, let's say 3 years. The producer, who is called the lessee, the landowner is called the lessor, has 3 years to get a bit in the ground and start the process of producing oil and gas. But it's after that specific time that then you run into all kinds of the different flavors of the habendum, which means, is Latin to hold the lease. We've seen, as long as oil or gas is found, as long as oil or gas is produced, or the really broad one is capable of being produced. How do you prove that it's not capable of being produced? Those are, of course, a lot of these leases were written by the producers, and therefore they're as broad as they can. And so long as you get a certain amount of cubic feet per year of free gas, that's really all you cared about.
Right.
As a landowner. Because nobody, when these old leases were signed, foresaw the shale well boom.
Oh no. And those leases are pretty often little tiny small font, but like on a single page. Sometimes they'll have things written into them that are different, but a lot of times it's the same form. And it was just, you want to lease for gas? There you go, to get gas to your house.
That's right. So this is an area when we talk about, can you break a lease, that has really been influenced over the past, let's say, 10 years by the public policy of the state of Ohio, which is to produce oil and gas. Okay, that's what the legislature has set. That's what successive numbers of governors have said. It is the public policy of the state of Ohio to produce oil and gas, and the state is going to do everything it can to favor that policy. Unfortunately, that definition of progress is often on the backs of landowners' rights. And in other words, we're going to produce oil and gas, very similar to the public policy a century ago of we're going to produce coal. And landowners, sorry, but this is important for the greater good of the community, however you define that. So we will run into situations where a client will come in and say, listen, I haven't been paid royalties as provided in the lease. The lease is a contract. Lawyers say it is, and the courts have found leases are contracts. So if I haven't been paid, the contract is broken, and I should be able to get out of it, right?
Well, my answer is usually maybe, it depends.
Or it ain't necessarily so, which
Right.
is kind of my
That's a
theme.
slogan for this.
Yeah, that's the slogan. It ain't necessarily so, because the producer, who is called the lessee, can at any time pay you back royalties and the lease is still good. And that's the first thing they do when your lawyer sends them a letter or something about that is, oh, well, let's check and make sure that we have been sending our royalties, which are often very, very small on these old wells.
Right.
Oldest well you've ever run into is?
You asked me too fast. Still producing now, oldest. I wouldn't say like 19 teens. I know the 20s I've seen producing wells. I think in the teens.
Very early on, we had a well that was drilled in 1910. It still had the wooden derrick above it, the structure above it, and was still allegedly producing. So some of these shallow wells that are called can produce for a long, long time, especially if the producer has kept up with them and gotten the paraffin out and maintained the wells. The courts, when they talk about breaking a lease, will often cite a legal maxim called the law abhors a forfeiture. Can you explain a little bit about that to folks who are listening?
I mean, it's basically just the idea that having an automatic forfeiture is not the preference, right? That's kind of a last resort. So it's not the default.
And it's something that has been repeatedly applied to landowners who are trying to break leases.
Right.
In other words, the courts are saying, listen, it's the policy of the state of Ohio to produce oil and gas. You can't do that without a lease. So we're going to really make the landowner jump through hoops in order to break the lease, because what we're doing is judicially taking away a valuable asset from this oil and gas producer, contrary to the policy of the state. So then the client goes, well, this old well has not been producing. So under the terms of the lease, it's expired, right? And I can break the lease.
Well, I think it's the slogan, right? It ain't necessarily
so. Okay. The first thing that I think you and I would probably ask the person is, it hasn't been producing, you haven't gotten royalties. Are you the person who signed the original lease? And oftentimes it's, no, I bought it from somebody else, or it's been through several generations in my family.
Right.
And what is the lessor, or the person who owns the property of the lease? If there's a change in ownership, what are you required to do generally?
Usually, and a lot of leases say this, that the new owner or the lessor or their next successors have to inform the lessee, whoever that is now, which it also changes,
Right.
but inform them of the ownership. So sometimes, I think pretty often that doesn't happen. People
Right.
don't know they need to do that. So then that lessee is just not paying anybody or paying the wrong person because they were never informed.
That's right. Two issues that you identified there. Number one, oil and gas producers trade these leases like baseball trading cards sometimes.
Sometimes pieces of them.
And sometimes it's very hard to determine if you go to the recorder's office and look, because of the concept of what's called a joint venture, which is a partnership. And companies can have these agreements, some of which are of the public record and some of which are not. And so it's sometimes very difficult as a landowner to determine who is the lessee, who is the producer in this lease.
Right.
Second, I've read a lot of leases, as you have, that require a new landowner to send a certified copy of the recorded deed that you got. And until the producer receives that, they're under no obligation to transfer the royalty interest to you.
Right.
So, okay, it's not producing, you're not getting royalties. Have you as a landowner fulfilled all your obligations under the lease?
Right.
Second, sometimes you go, well, it's all they're sending me is like a $5 check.
Right.
The royalties have got to be higher than that. And there is in most leases something called a shut-in royalty. Would you kind of like to take a crack at that?
Sure. Sometimes, especially in old leases, there might be a shut-in payment or a delay rental if they haven't drilled yet in an old well. And I've seen those. Sometimes they overlap or they look alike. So a shut-in payment or shut-in royalty would be, it depends on the language of the lease because everything comes down to what does that lease say. But usually it's if there's not production for so long. In the old leases, it might be we can shut in a well, like not produce it, close it up. And every year we owe you $5 and we can keep our lease because we paid you $5 or right. Whatever the lease says.
That's right. So often a very small amount. Number one, that did not stop for predecessor owners the flow of free gas because your free gas comes off the wellhead.
Right.
And if it's shut in, fine, that's just more natural gas.
You're just getting your gas anyway.
Yeah, you're
right.
just getting your gas anyway. But yeah, shut-in royalties are often a problem. The concept is that the producer should not be required to produce all the time. There needs to be some downtime. If the market drops and it's just not profitable to sell, especially natural gas, then you can shut the well in for economic purposes, not only oil and gas engineering purposes. This all leads us then to a discussion of what we call held by production. That is the lease. This is the producer's favorite term. This lease is held. That is, it continues to be in full force and effect because we are producing under the lease. Are oil and gas producers required to report anything to this state?
They are. On the shallow wells, which I always think it's funny that we call them shallow wells, and they're still like 5,000 feet deep, but they're just a straight,
but they're shallow.
Yep, yeah, they're shallow because it's all relative, right? But it's one straight vertical well that's shallow. I believe they have to report production of those wells annually.
Correct.
Horizontal wells, which we'll talk more about. I mean, we talk about it all the time, but I know when we talk about unitization, we'll talk more about them. That production gets reported quarterly.
Right.
So, and anyone can look and see what an operator has reported to ODNR, depending on the type of well. So
a client comes in, we got their lease, we look up their property, we see what the Department of Natural Resources has in its oil and gas well locator, which anybody can look up. It's overlaid over the auditor's tax map of parcels of land, so you can tell where that unit is, where that production unit is in relation to your property. And then you just double click on it and it takes you to where the oil and gas producer has what they've reported. And in at least the old wells, they were required to report oil production, gas production, and I believe brine.
Yes.
Is that right? Okay. So there's no production. You're home free, right?
Well, not really, no. And sometimes you pull it up, right, it ain't necessarily so. And you'll pull up the report and there'll be 10 years of zeros. Or, I mean, if you check out enough wells, like all the reports kind of look alike and the amount just change, right? But that, I mean, all of these questions that you're talking about are things that even looking at the report and it says zero, I mean, that's not necessarily true that your lease isn't held.
You would think, and because let's face it, there's a tax called ad valorem tax. It's based upon production of oil and gas that the state has. that if somebody got a hold of yours or my state income tax returns and we said we made $50,000 in a year, that could be used against you. That's what you made. But it ain't necessarily so with what oil and gas producers report to the state. With older wells, I think we've run into two issues. Number one, the state permits older wells, so-called shallow wells, to be hooked up in what's called batteries. That is, you run from several wells into one set of tanks for oil or one distribution point into a transmission line for natural gas, and therefore it's really not possible to tell what an individual well produced in that situation. And that's not on the report.
Well, I think all of those, I don't know how you would tell from the reports. And sometimes several wells reports will be identical. Correct. And that may be because that's the battery.
Yeah, and then they divide it out between the wells mathematically, but that
Right.
doesn't mean whether the well in question is still producing or
Right.
not. Okay, it's just that's the mathematical distribution. And then we run into this even in the deeper well situations. The producer is not bound by those reports because, can you explain a little bit about how oil is not oil?
I'll try.
Okay.
You know, that's a hard question. I
is.
think, so this is my understanding of this, right? And you tell me if you don't agree with my summary.
Well, I don't agree with the producer's position on this because
sure.
I think it's sleight of hand, but it is a legal argument that they make that some courts have adopted, right?
Right.
So we got to be prepared for it.
And I think I think it comes down to the reports that are made to the Department of Natural Resources. Anything that's liquid is reported as oil, and anything that's gas is reported as gas. At the end of the day, when they're selling product, those things change depending on pressure and temperature and all sorts of things. And so what they sell might not be liquid that's oil. It might be natural gas liquids or something else. So it's what gets reported is not necessarily the same as what's sold. So oil is not always oil. It's condensate or all of these other things that might be liquid sometimes. So it is not clear.
And we deal with these issues every day on behalf of clients, and it's hard for us to wrap our mind around these issues, right? Because
Sure.
basically we think what the producers are doing is just mucking up the figures so they don't have to account.
We can
right?
report one thing and what
And
happens afterwards.
And say it ain't necessarily so.
Right.
So one term that you mentioned earlier was the concept of paying quantities, okay? That is a well producing and paying quantities. And I think most people, when you look at that term, you'd think, well, there's the gross production, the value of the gross production. You deduct the value of the cost of production. And that if that gives you a difference, then that's your profit. That's a paying quantity.
Right.
And unfortunately, it ain't necessarily so
Right.
that's the definition.
Yeah. That would make sense, but that's not what it is.
Yeah, but the courts have been fairly consistent in the courts of appeals. I'm not aware of the Supreme Court dealing with this yet. But in the courts of appeals that deal with this, the test is, would a reasonable producer in the same circumstance still work this well and thereby hold the lease? And it doesn't mean profitable, because there are other reasons that the courts have found that you would hold on to a non-profitable well. The primary one of which is
To hold on to deep rights for those horizontal, the wells that are deeper.
absolutely
Right.
and that is to hold deep rights, and that is often the bone of contention between people who have ignored these shallow wells for decades, and the landowner who says, listen, this is not producing in paying quantities. It just doesn't make sense.
Right.
But the courts have, once again, abhorring a forfeiture, don't want to break a lease, have given oil and gas producers a lot of leeway in that regard. So Kate, let's say we find that our client has grounds to break the lease, that the lease is no longer living in the analogy that we used, and we send a letter on behalf of our client saying, listen, you need to cancel this lease, you need to forfeit the lease, and of course we get back from the producer, no, this is held by production, okay? If the client wants us to, what's our next step? How do we get a determination as to whether the lease is still valid or not?
Well, usually at that point, after demanding forfeiture, which a lot of producers will show up, like you said, and say, oh no,
Right.
like we want to hold this because they probably have deep rights that they've sold or could sell.
Right.
At that point, you're probably talking about a declaratory judgment, right? So filing a lawsuit to have a court determine that the lease is forfeited, which still can be an uphill battle for all the reasons that you said so far,
Sure.
even today, right?
And a declaratory judgment is normally when you think of filing a lawsuit, you're talking about one side saying the other side owes them some money for whatever. You know, you rear-ended me or you caused damage to me, et cetera. And there are some situations where a landowner has been damaged, but a declaratory judgment lawsuit kind of grew up in the insurance agency. I'm sure many of our listeners have made an insurance claim, and the insurance company says, sorry, writer 42 on page 55 of your policy says you're not covered, there's a dispute. And the declaratory judgment statute permits two parties who are disagreeing about their rights vis-a-vis each other to go to a judge, and the judge declares what those rights are. That's why it's called a declaratory judgment. And then we start in the adventure of oil and gas litigation, which we probably need to do a separate podcast on.
Probably.
What that litigation looks like. And the issue is oftentimes the producers have more resources to devote to this litigation process than most landowners. That's something we run into all the time.
Sure, it is.
They're the ones trotting out the multiple experts in a
Right.
case. We may have one or two, and but here's the issue: the power of the producers is so great that you really can't call your congressman or call your state representative, because legislature is going to be controlled by who donates most to political campaigns, and that ain't landowners. The only chance that oftentimes landowners have to justice is to go to court and to
Sure.
seek redress through the court. So that's what we have to do. But producers are very, very hard to convince. Listen, you've got an issue here. Once we do convince them, then we can reach a settlement, or we can go ahead and win the case and break the lease. Speaking of which, I remember early on, I think it was in Noble County, we had a case where literally the only remnants of the well was the casing, the pipe, sticking up in the middle of a hayfield. There's no pump, there's no pump jack, there's no gas lines attached to it, there's nothing, just a pipe in the middle of the field, and the producer was arguing, oh, this property is held by the production of that well. I mean, I remember we took photos of this pipe, and it took the longest time just to convince them, no, they don't have a case, and they eventually forfeited the lease. And that's unfortunately what we have to do quite often. But sometimes producers will go too far in making representations about production or about royalties under a lease. And then there's an issue of what lawyers call fraud.
Sure.
Can you give us a quick definition of that?
Well, I mean, a quick definition of fraud.
Sure.
Basically, I would say, man, Tom, that's hard. A quick definition: a material misrepresentation. You're
Gotta remember,
covering up and
I used
hiding
to
something.
teach law school, so
I know.
I'm good at answering.
But I was just
asking these
talking
questions.
about this yesterday, and there are 6 elements of fraud, and I have them in my head.
I'm not asking for
I know
what we
you're
would
not.
plead.
I know. You're hiding something, covering it up,
Sure.
lying about it.
It's deceit.
Fraud. Right.
It is something that you are lying about that you count on the other side to rely on to their detriment. They're damaged by their reliance. And that
Right.
kind of, I know there are 6 elements. And
I know.
That was what you'd have to put on the bar exam.
It's just like in my head today.
Sure. So But sometimes oil and gas producers will go too far. They'll fudge things, and if we can catch them at it, then maybe we have another claim for something like fraud, and are able to take care of it. So suffice it to say that if you, one of our listeners, is looking at a lease, and maybe you're in an area where the oil and gas production field is expanding to. We're starting to see it go farther west, a little bit farther north than it has been in Ohio. And you're interested, it's at least worth bringing it in and having Kate or me or another partner, Chris, take a look at it, see what we can find, and see what our opportunities are to maximize the benefit in your mineral interest.
Yeah, we'd be happy to.
All right. Well, that's it for It Ain't Necessarily So, the discussion of breaking leases. Thank you.